Runner, my name is Stock Initial R, and I am here with my learner junior, Lawson Initial H, for the defendant, friends in the pipeline. Your Honour, I wish to seek leave to dispense with full citations. The circumstances in which the entrant arrived at the premises has relevance to the standard of care and the scope of the duty as per the judgment in Australian Safeway Stores v. Lawson in 1987, where the occupier's liability for lawful entrant exceeds that of an unlawful entrant, and that the standard of care owed to children and the elderly exceeds that of a reasonably healthy adult. As the occupier of the premises, friends in the pipeline, concede that there was a duty of care owed to all lawful entrants on the property in line with an occupier's duty of care principles outlined below. In reliance upon the case of Pascoe and Coulomb, the plaintiff must concede the key point whereby the liability of an employer is greater than the duty to other occupiers, and that in this case a significant factor in the imposition of the liability was that Pascoe was in the employ of Coulomb Resort and they were obligated to provide a safe working environment. The judgment comments on the fact that the depression in the pebbles in this case is not something unusual or unexpected, rather an ordinary fact of life encountered every day by pedestrians. Further on this point, the case of Ellis v. Uniting Church Property Trust comments that the difference in the duty of residential, commercial and public occupiers is irrelevant to the imposition of liability. The classification as an ordinary residential property, as set out in the judgment of Ellis and Niendorf v. Junkovich, speaks as to the standard of care and the scope of liability, with Ellis drawing particular attention to the areas on the property where the occupier's land meets the public footpath, in this case the area where the slip and fall has occurred. The crossover between privately controlled property and public land is important, as the friends in the pipeline are not the usual occupier of the public footpath, and therefore have no control over how entrants to their property use the area, consequently limiting their liability for incidents occurring on the public footpath. Evidence acknowledging the potential risk of the depression in the pebbles does not create a breach of liability for failure to take preventative measures. Wyong Shire Council v. Shirt in 1980 speaks to the assessment of risk posed and how, when it is considered reasonably foreseeable, although it does not pose a great risk, there is no liability. In concession that someone slipping on a depression in pebbles is reasonably foreseeable, the defendant argues that the risk and probability of serious injury is remote, therefore justifying the adequacy and maintenance program which the friends in the pipeline had implemented. On this point, although acknowledged as a potential hazard, the depression in the pebbles and associated maintenance are adequate in terms of that required by the Ellis and Uniting Church judgment, where again the foreseeability of an injury arising from the hazard was conceded, but the nature of the hazard was too mundane to breach the duty of care by failing to remove the hazard. The plaintiff's case is also supported by the judgment of Turnbull and Alm and Anor, where permanent and lasting remedies for hazards were required in the judgment. However, by employing staff to maintain the property in a safe manner, friends in the pipeline have satisfied such a requirement, and the potential hazard created by the pebbles are of a nature that common law finds to be within the norm encountered by a pedestrian. Therefore, the existence of the depression between raking does not create a breach. Evidence also supports a finding that the depression was not concealed and was visible and predictable as conceded by the plaintiff. Here, Garnthouse and Hawkesbury City Council 2001 applies, where the judge found that the difference in height in question, as in this case, was clear enough to see that a pedestrian taking ordinary care would have noticed. On the date of the incident in question, submissions suggest that the conditions were not ideal and that there was only dim lighting available. However, it was not so dark that a courier could not reasonably see the potential hazard. Such as were the findings in Ellis and Uniting Church and Turnbull and Alm and Anor, where the judgments make comment as to the poor lighting conditions not being relevant when the hazard is of a nature that the pedestrian could reasonably be expected to see it. Friends in the pipeline have done what is reasonable and practicable concerning maintenance of the safe driveway. They have taken all reasonable measures for the driveway to be safe for someone taking reasonable care when walking on it, as per the standards set out in Gant House and Hawkesbury City Council and Rosenberry and Percival. The plaintiff acknowledged the risk posed by the pebbles and the area between the concrete strips as per those in the property in question. Therefore, in this knowledge, she has assumed the risk posed by any depression in the pebbles where she chose to cut the corner of the concrete. Further to this, a courier wearing high-heeled shoes adds to the risk which she assumed on that day when she cut the corner of the concrete. There must be acknowledgement of significant contribution to her injuries by a courier. On point concerning the duty of care owed, Littler and Liverpool's Corporation commented that highways or public footpaths are not to be criticised by the standards of a bowling green. In line with this judgment and that of Gant House and Ellis, there has been no breach of duty. Thank you, Your Honour.
My name is Lawson, initial H. I represent my client's friends in the pipeline. Your Honour, I wish to seek leave to dispense with full citations. Following on from my learned friend's submission, our client is not liable for the injuries incurred to a courier from the alleged robbery and sexual assault, as it was not a direct and foreseeable consequence of a courier's fall. Your Honour, it could not be a directly and foreseeable consequence that an injury incurred by a courier would result from the alleged robbery and 5 weeks later being sexually assaulted as a result of the above incident referred to by my learned friend. Novus actus vis intervenus supports our client, as the actions that have occurred have been by a third party. This then breaks the chain of causation. May I also bring to Your Honour's attention the passage of time protects our client from liability, in that time has passed from the first incident which occurred. Furthermore, Your Honour, under Section 11, Sub 4 of the Civil Liability Act 2003, operates to protect our client from liability. It requires normative consideration to our client's liability. Your Honour, it could not be that it was reasonably foreseeable that subsequent to a fall, a courier would then be robbed and sexually assaulted. Pursuant to subsection 4, it must be considered whether the damage incurred by a courier was a reasonably foreseeable consequence of a courier's fall. The fundamental importance is reasonably foreseeability of the robbery and sexual assault resulting from a simple fall. It could not have been foreseen that from a simple fall the following actions would have occurred. In relation to the PTSD and economic loss, our client is not liable, as a third party caused the injuries and the incident is remote, as in Bolton-Stone remoteness and likelihood of injury. As per the above arguments, the sexual assault itself is too remote for the action or omission by our client, and therefore all injury resulting from a sexual assault falls outside Friends of the Pipeline's liability under the principles of negligence. From this, Your Honour, it falls outside the client's liability under the principles of negligence. On the basis of the above submissions, counsel for the defendant respectfully requests that the defendant not be found liable for a courier's injury and her claim not to proceed.